Was splendid. Okay, doesn't work. Okay, so before we start, if you don't mind, we'd like to make a little break just for delivering little souvenirs for honorable guests. So guys, before you leave, please we'd like to give you something from the university. Thank you. Yes, just a moment, please. If you don't mind, we'd like to deliver the things. Thank you. So again, we are really honored by your participation in our meeting. I hope it's the beginning of the cooperation, and obviously it's communicated, is directed to you all. So thank you for your participation, thank you for your presence, and I believe it's the beginning of something new, something huge. Okay, so that's it. And Professor, would you like to go? Thank you.
It's a pleasure. That's great. Thank you very much.
What will I do later?
Oh, wow, tá bom? Very much. Lucas, tá bonito, tá bonito. Pegar aqui, vou tomar uma. Esse é meu, esse é meu. Não, não, esse é meu, acabei de deixar aqui. Eu acabei de deixar aqui.
Okay. Okay, so as usually during such a conferences, we are out of the schedule. So I would like to prolong, and this is the very best moment to open the third issue of the plenary session. And for now, I would like to introduce Professor Claudia Gonçalves. Thank you. Professor of Business Law at the University of Almeria, Spain, who will present the paper entitled "The EU Proposed AI Compliance, a Critical Analysis." Okay, so Professor, the floor is yours.
She's online.
Yes, she's online, of course.
Hi, good afternoon. Hi. You can listen me? Professor? Professor?
Yes, we hear you.
Okay. Thank you so much. Thank you. Sorry. Okay. And I start in the moment, please.
Here come instructions in the background. So would you be so kind to maybe moderate something on your side?
Claro, porque la carrera es bonita. Si al final aprendemos en la calle todo, si esa base de que no vale para nada. Ya que yo en la carrera
So sorry, I have a little problem here. I try.
Tutaj właśnie można czasami po naszej stronie po prostu. Państwo mają jeszcze na wszystko powinno być widoczne, więc albo komentarze ludzie po prostu. Tutaj jest wiadomo.
Nie, bo nie ma rzeczywiście.
Ja pani ma też włączone, więc to tak.
Okay. So very sorry for this technical break. We'll try to solve it problem as soon as possible.
Bo coś z internetem nie bardzo.
Okay, so we will try again, and if we can't solve the problem for now, we will try to reverse the order of the presentations. We do not have the feedback from Professor Gonçalves, unfortunately, for now, even though she was trying to connect us. Okay, so not to prolong, in this situation, I would like to ask Professor Mariusz Załucki, the full professor of law at the Ignatianum University in Krakow, and also Justice of the Supreme Court of Poland, to start his presentation entitled Personal Rights in Environmental Matters. And if we have the opportunity, of course, we'll come back to Professor Claudia. I think it's the only reasonable solution here.
Ja się to występuje. Okay. Changes are always happening during such a conference, but hello once again. It is a pleasure for me to share with you some thoughts about the things I didn't consider important until I have started to think about them in the preparation for this conference. So I am very happy that the organizers let me to share these thoughts with you in this session. As you know, environmental protection is increasingly ceasing to be the exclusive domain of the administrative law. And in recent years, we have seen a clear shift towards civil law protection, in particular the protection of an individual's personal rights, which are violated as a result of environmental degradation. Claims related to the protection of personal rights are therefore beginning to play a special role, especially in cases where environmental impacts such as noise, vibrations, or air pollution directly affect individuals' living condition. As case law in Poland has shown in recent years, this applies in particular to the areas located near the airports, where the conflict between the public interest and the protection of individual rights is most intense. So before I will get into that, let me explain to you the aim of my presentation. I would like to discuss with you the concept of personal rights protection, of course, in the context of a clean environment, the evolution of the case law in Poland, the significance of key rulings, as well as the practical consequences of the current line of jurisprudence for individuals and also maybe for some public authorities. At this juncture, a fundamental question arises. Can the right to live in a clean environment be considered a personal right? Or maybe environmental protection shall be achieved solely through the protection of other rights? I have to add that I will be dealing mostly with Polish law, as there are no universal principles in this area, and the numerous, or maybe what is more important, that the numerous jurisprudential problems have arisen in Poland lately. They may serve as an interesting inspiration for other jurisdictions. So as it regards the legal basis for the considerations, the constitutional background is important. Since in civil law, the basis for the claims first remains Articles 23 and 24 of the Polish Civil Code, their interpretation must be strongly linked to the constitutional norms, in particular Articles 68 and 74 of the Polish Constitution. You can see these norms on the screen. It is interesting that Article 74 of the Constitution of the Republic of Poland concerns ecological safety and environmental protection. The key points are the state's environmental policy, the obligation to protect the environment, the rights of citizens to information, and support for their pro-environmental activities. And at the same time, in, let's call it airport matters, it is worth mentioning that the Polish environmental protection law introduced to our national law a very interesting institution, the so-called restricted use area. That area is a special legal zone in which it is permissible to exceed environmental quality standards. So the dispute, therefore, focuses on the relationship between this administrative regime and civil law protection. The point reference for the protection of personal rights in Poland in such cases concerning the environment remains the Supreme Court's resolution of 2021. And in that resolution clearly stated that the right to live in a clean environment does not constitute an independent personal right. At the same time, the Supreme Court clearly emphasized that violation of environmental standards may lead to the violation of other personal rights, such as health or privacy. And this reasoning is also fully applicable in cases concerning aircraft noise. In the light of the Supreme Court's resolution, the earlier, especially the later case of the common courts, which often took a more flexible approach, takes on particular significance. The common courts have analyzed, among other things, the prolonged traffic noise as a violation of the right to privacy, right to domestic peace, and unpleasant odors as interference with the unviability of home, air pollution as a factor leading to a deterioration in mental and physical health. It is worth noting that courts are increasingly moving away from this formalistic approach and are examining the real environmental impact on the life of the individual. So rather than merely exceeding administrative standards. There have been some interesting cases concerning aircraft noise. The Supreme Court case law has also established, for example, that the right to silence is not a separate personal rights, but excessive noise may lead to the violation of other protected rights. Already in the judgment of 2011, the Supreme Court indicated that this prolonged noise, including what is important, noise from legally operating infrastructure, that would be the airport, may violate health, the right to privacy, and the right to domestic peace. Similar position was taken in the Supreme Court judgment of 2019, emphasizing that the legality of an activity, including an airport, does not automatically exclude the unlawfulness of the violation of personal rights within the meaning of Article 23 and 24 of the Polish Civil Code. So the cases related to the operation of airports covered by these restricted use areas are of particular importance for the development of environmental case law in Poland, especially when we are considering the Chopin Airport in Warsaw and Poznań Airport. These airport cases are precedent-setting for several reasons. Well, first of all, they concern long-term and systemic impacts. The defendants are often interesting because they are large infrastructure entities or the state treasury, and also they reveal the limits of acceptable interference in private life. So from the perspective of the protection of personal rights, it is crucial to, according to this case law, it is crucial to demonstrate the intensity and frequency of noise, its impact on health or family life, and the individual nature of the harm suffered. It seems like the protection of personal rights in environmental cases serve or may serve several important functions. It enables compensation for the harm suffered. It can effectively discourage excessively burdensome activities, or it strengthens environmental protection by involving individuals as active subjects of legal protection. So importantly, this form of protection individualizes the environmental problem within human dimension, which increases its significance both in public debate and in court practice. So if I was to give, if I was supposed to give any conclusion to what I have just presented, I think I would say that all these issues may lead to the conclusion that although Polish civil law does not protect the environment as an abstract good, it does protect individuals from the effects of its degradation. And the protection of personal rights is now one of the most important tools for protecting individuals from the effects of environmental degradation. So these course rulings, some of them I have presented, they show that the protection of personal rights is becoming a real instrument for balancing the public interest and the individual rights. So as a result, we can speak of the gradual development of civil law standards of environmental protection oriented towards human being, and that complements traditional instruments of administrative and also constitutional. What the future will bring, we don't know whether there will be any massive environmental law legislative initiative in Poland or within EU, we'll see. But until now, the civil law will, until then, the civil law will supplement administrative and constitutional law. Thank you for your attention.
Professor, thank you very much for this very well organized and impressive presentation. And now I would like to ask whether we have the possibility to connect to Professor Claudia, whether it's possible. If we are still suffering from some technical obstacles.
Why is the back? I don't know. I can find it. In documents from you. And you will page.
Okay.
12.
The situation seemingly didn't improve. So in such a situation, for now we're making preparations for presentation, which will be given by Professor Fabio da Silva Veiga, Professor of Business Law at the Lusofona University, Portugal, who will present his paper entitled Sustainability Regulation in Companies in the European Union. Okay, so Professor, the floor is yours.
Just change it. We can change it. Thank you very much, Professor Marcin. My topic is comparative due growth concept. Is the topic I research in the University of Almeria, Madrid, but I work too in Portugal. The theme of the company due diligence is a theme very important. I have been researching the topic of corporate law due diligence for several years. Initially, I approached it from the perspective of business law, particularly corporate law, focusing on the power structure within business organizations. From this perspective, the topic is regulated by commercial law codes and the laws, which state that corporate management bodies, for example, boards of directors, executive officers, must act with care and diligence based on technical capacity, qualified information, and ultimately prioritizing the company's interests above all else, including those of shareholders and other stakeholders. This due diligence in the business context has always been linked to an internal legal duty of the company, aimed at preserving corporate interest, namely economic sustainability and profit distribution among shareholders. However, this legal concept of due diligence traditionally tied to corporate management that has been undergoing conceptual expansion, driven especially by political debates within the United Nations and other international organizations such as the OECD and the ILO, International Labour Organization. These institutions have increasingly emphasized to impact that business have in human rights and the environment. The main soft law instruments that address the human rights and the environmental impacts of companies include soft law instruments, for example, United Nations Guideline Principles on Business and Human Rights from 2011, OECD Guidelines for Multinational Enterprises, first published in 1976 and updated in 2000, 2011, and 2023. Three topics, UN and ILO covenants and conventions, for example, many instruments for regulation in soft law, but these instruments not use enforcement, no have enforcement, no? And others legislation, for example, national laws, regulation in France, and France was the pioneer in 2017, followed by the Netherlands 2019, Germany 2021, Norway 2021. Internationally, other countries have adopted transparency regulations in global value chains, such as California's transparency in supply chains, UK Modern Slavery Act, Australian Modern Slavery Act. Key distinction. Due diligence laws require companies to effectively adopt a set of actions to address, identify the risks. These actions must involve engagement with the information actors throughout the value chain, aiming to provoke real change that prevents negative impacts, minimizes risks, and avoids harm. The new Corporate Sustainability Due Diligence Directive is now is a great discussion about this directive. Part of the international and European regulatory movement in 2024, the European Parliament adopted the Directive 2024-1760, and the matter is identifying private and mitigated and remediate negative impacts on human rights and the environment in their operation and global value chains. However, due to the complexity of transposing this directive into national law, in April 2025 this year, the European Parliament adopted directive, other numbers, maybe Stop the Clock, which extended the implementation deadlines. Originally set for July the next year, but the Parliament changed the dates from July 17 and 2020, 27 and 29. In this month, on December, the presidency of the Council and the negotiators from the European Parliament reached a provisional agreement to simplify sustainability reporting and the due diligence requirements with the aim of boosting EU and competitiveness. The agreement simplifies the Corporate Sustainability Reporting Directive, the SRRD Directive, and the Corporate Sustainability Due Diligence Directive, reducing the burden of reporting information and limiting the casting effect in smaller companies. This is very information very important because this is change the perspective for the future in this directive. Others legislation about the themes, for example, regulation 95/29, many directives and others instruments for regulation the human rights and the companies. But my conclusion, best conclusion is And the concept of business due diligence has transcended private corporate interest. The growing discussion around the impact of corporate activity on society has shaped notions of business responsibility. Due diligence now carries an external binding obligation. Companies must create vigilance and precautionary plans to mitigate risks of human rights and environmental violations. This responsibility for oversight has been transferred to companies. States are no longer the sole protectors of human rights. Under this new framework, companies are required to assume full responsibility for their entire value chain. If victims or environmental damage result from a company's failure to meet due diligence obligation, the company may be held liable. Conclusion 2. In short, sustainability is not just an ethical goal, but now an essential element of global economic and political governance. The European Union has played a key role in promoting policies and regulatory instruments capable of guiding companies towards responsible practices, reconciling competitiveness and respect for ecological limits. However, recent legislative revisions, such as the Omnibus Package, the Stop the Clock Directive, and the Provisional Agreements of the European Council, highlight the tensions between environmental ambitions and the economic and geopolitical pressures of Europe's most industrialized countries, for example, Germany and Italy and Denmark, as these countries have perceived the risk to the competitiveness of European companies on the global value scale. Thank you very much for your attention.
Thank you, Professor. Also, thank you very much for being very strict with the timing of the presentation. Whatsoever. Okay, so now again, I'd like to ask whether we have connection with Professor Claudia Gonçalves or not.
Can you see Claudia? Speaking to Claudia. I was trying to connect with her problem. Technical problem, so for now, no.
Yeah, so maybe we could postpone the lecture
Yes,
till tomorrow.
maybe.
So we have no room to reestablish the connection.
During Christmas Eve.
Yeah. Why not? Okay, so we are having 10 minutes for now. And if so, I would like to ask whether you would like to ask the audience whether you would like to pose any questions for our prelegents dedicated to these presentations. Yes, please, Professor.
Mike. Please use the mic. Inside, they don't hear you online.
Because you mainly described the European Union regulation, and then your conclusion was that the sustainability it's a global goal of the global politics and economic. Is it really the conclusion right when you are talking only about the European Union and maybe and the Great Britain, Australia, and some other developed countries? Of course, the other are also developed, but not necessarily they perceive sustainability as their goal and at least the goal of the year of economics. What is the position of our continent in the major economic powers beside the European Union and maybe also the US and Australia?
Did you understood?
The question I don't understand.
Sustainability is not only business, it's a global one. Big projects, some other countries too, but there are countries. Okay.
Thank you, Professor. Yes, the question is important, interesting. And in my opinion, the regulation, the sustainability is very hard. It's not easy, but each color regulation ER jurisdiction. No? But the term sustainability is more expensive. In my opinion, for example, Europe try to regulation because the companies, European companies, are around the world, and European try and consider the values, the European values, but this for me for the application, the regulation about the sustainability in Europe is not easy, and other countries, for example, Denmark, other countries in Europe, Denmark or Germany and Italy don't want to change the regulatory of sustainability, but the other countries, UK, for example, in the past month, judged case in the operation company Australian Britain company make operation in Brazil, and this case was judged in London, and I think the different countries can make regulation and sustainability, depending the countries is efficient or not.
If I may, maybe the question wasn't addressed to me, but I would like to share some thoughts also with you. Because I do believe that this word sustainability, it's a little bit of a marketing tool. For example, in my hometown, we wanted to build a new seat for the district court, but the local government does not have any money. But then they have asked the country authorities and the Ministry of Justice to give the money to build the new seat of the district court, because sustainability has to be reflected, and since other cities has a new seat of the district court, Rzeszów also shall have one. And the Ministry of Justice said, yes, definitely, sustainability, we have the money for sustainability, let's do it. So in these circumstances, it sounds like a marketing tool, and maybe I kind of understand why he said that it should be a global goal. But of course, we have to consider those countries that you have mentioned, that it is not possible now, but maybe in the future, if we have too much money, we can think about sustainability also there. So let's see. It is kind of like a new rule of law. Anything fits there, as you can see in our presentations.
Okay, so thank you very much. And I would say that this borderline, this interconnection between architecture and sustainability and law seems to be very fruitful and challenging field of research. Basically, it's nothing new, because I was thinking about the Gothic architecture, but also about architecture and sustainability, but in a different perspective. Okay, so if there is no further questions, I think it's a good moment to invite everyone for maybe 10 minutes on break, because we are foreseeing a quite intensive session in a moment. So in such a situation, thank you sincerely for your presence here, and maybe we'll meet in 10 minutes. But I just try to emphasize that from this moment, there will be two separated sessions. And if you'd like to participate in the second one, it will be located just on the other side of the corridor, with also beautiful night view on the downtown. So enjoy it. See you for a minute.
Thank you, sir.
Thank you very much, Marcin.
My pleasure.
A picture, please.